na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Big it up. Oh na 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 na. Dig it up. Oh na 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 na. Bam bam. Bam 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 day. Bam bam. Bam bam day. Bam 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 day.
Hello everyone, it's Robert Taylor from Taylor Law Jamaica. Welcome to Home and Away Jamaica TV. Happy to be with you here another day, and with me is
Paulette Price, and I'm a real estate broker.
Thanks, Paulette. It's good for us to be here again. Last week we had a special guest, and today what we're going to be doing on the program is fielding and responding to some questions that have come into us by email. Most of these questions are legal in nature, and so Paulette, what I think I'm going to do is just go through these questions and perhaps just from the perspective of what some of your clients may want to know, you may ask some questions, and I'll try my best to simplify them or give some simple answers. So one of the first questions is, how do you go about granting power of attorney? And so this question, I imagine, has to do with a concern that many persons have, or familiarity that many persons have with the ability to convey instructions to a third party on their behalf. So a power of attorney is a formal arrangement by which one person, who we call the donor, gives another person, who we call the attorney, the authority to act on his or her behalf and in his name. Now, the term attorney doesn't refer to a trained attorney in the legal sense, but someone who's been given this expressed authority. It can be a relative, it can be a trusted third party, recognizing as well that when you give this authority, it needs to be someone that you can repose trust in, because you're transferring effectively the right or interest you have in a particular transaction to that third party or that attorney. So powers are particularly useful when dealing with land transactions, where, for example, a registered owner resides overseas but is unable to travel, perhaps to due health, or just simply the fact that it may be more convenient to issue those instructions remotely. Particularly, we're seeing now in the time of the COVID pandemic, more persons are less willing to transact in person. So a power of attorney would be an effective means of conveying or transferring authority to a third party. Say you reside in the UK and you're hoping to sell property, you can issue written instructions to a relative, as I said before, a trusted person who can carry out those instructions, whether it is renting property on your behalf or actually conveying or selling property on your behalf. What I would also suggest is that there is actually on the National Land Agency website a pre-done format or template that can be used for powers of attorney involving land transactions. So in that form, you'd simply go online, download it, insert the property details that you would have from the certificate of title, the volume and folio number, and have it signed, have it witnessed by a notary or an attorney at law or justice of the peace. Have that document dispatched, courier to Jamaica. We would need to make sure that that power is registered pursuant to the Registration of Titles Act. And as it must be executed as a deed, it must be stamped with the requisite stamp duty and recorded in the Island Record Office. That's something that you can have an attorney in Jamaica, as in a attorney at law, handle on your behalf, or certainly, again, someone that you may trust in handling your affairs, have them do that registration, and the stamping is for a nominal fee. The attorney, in fact, that person who you're issuing the power to, has to be over 18 years old, and as I said before, someone that you can trust in handling your affairs. So I think that gives a fairly succinct overview of the power of attorney. It's commonly used, I think very appropriate in this pandemic time. Persons are abroad, persons are not particularly keen on traveling and coming into their home country. The other question is, what steps can you take to ensure that your children inherit your legacy? And so I think it's a very good question, and it's something that we see lots of legal issues arising from, because persons fail to take appropriate steps to ensure that their legacy can be inherited by their children primarily, and any other beneficiary that they may so choose. Simple answer is to create a will. And many persons, one, have this resistance to creating a will because it, instills this sense of morbidity. We have to deal with our mortality. But the fact is, a simple will is all we need. We don't necessarily, while it's advisable to have legal advice, there are certain basic things that can be done to ensure that the will that you create, whether in handwriting, whether typed, is valid. And I'll go through some of those very basic checklist steps when we're through looking at the questions that have been asked. So to answer that question, to ensure that your legacy is preserved, create a will. Now, bear in mind that if you own property that's owned as a joint tenancy, meaning, let's say yourself and your spouse are together on that property as a joint tenant, you can't will your interest in that property. Under a joint tenancy, it is the surviving joint owner who holds that property. So if you own jointly, you can only will a share if you are registered as a tenant in common, not as a joint tenant. So that needs to be taken into account. What you also want to make sure is that the steps to validly create that will is done. The other way you can ensure your legacy is preserved is that during your lifetime, you can transfer any interest that you hold to the persons who you choose to benefit from your estate. So, for example, in Jamaica, if you go via probate, you may pay, subject to an initial threshold of value, 1.5% in death duties. And that death duties you pay during the probate process. Another option, though, is to transfer that interest in the land during your lifetime to that beneficiary. Now, you will pay 2% of the value of that asset, that real estate asset, in transfer tax. While you may pay 0.5% more, you may consider the fact that you can do that transfer in your lifetime, the convenience of it worth the additional cost, because then you are eliminating the hardship and the paperwork, as well as when the probate process needs to be managed. It takes a lot of responsibility on the part of the person who you would appoint that trustee or that executor. So my advice to many persons, you can simplify the process by simply doing a transfer during your lifetime. The same applies for other assets, whether it's bank accounts or other legacies you can transfer during your lifetime. If you choose not to, you can create a will, make sure the will is validly created. And what you don't want to happen is pass without making any arrangement and preserving that legacy. Because what then happens is that property goes intestate, meaning that the state will have control over those assets. You will have to make an application by way of a separate route, not probate, what we call letters of administration. And so letters of administration is where you apply to the state to appoint a trustee to administer the estate. And then there's a particular formula as to who gets what. So the formula may include a particular percentage for a spouse, for children, as well as siblings. So you don't want that to happen. It's messy, time consuming. That takes me to the third question.
Sorry, Robert, before you go to the next question, I just wanted to ask something about the will. I know you said it's very, very simple. So sometimes I get clients as well who don't want to, they still have that fear about the will like you talked about. So if somebody had just had a small house on their own and they had a couple of dollars in the bank, you're saying that making a will is as simple as writing that down on a sheet of paper and sealing it in an envelope. That's still also as good as a will?
Yes, it is. And so what I'll do when I'm done is just go through a checklist of things that that person would want to include. So the other question was, what is probate? So probate really is a document granted through the Supreme Court, certifying that the will is valid and authorizing the executors to administer the estate of the deceased persons. Now, why probate is particularly important and a critical part of the legal process is that in passing on property from one person, the deceased, to another person, is particularly a process that can be fraught with fraud. So what the courts have established is this process where the will can be proved valid and persons who benefit can properly benefit from what has been passed on to them. And so there's a particular process that has to be followed. There's an oath that has to be filed. The court goes through and proves the will. They review the will to make sure that particular steps are taken so that the person who prepared the will and executed the will, their intention is preserved and validly executed. What we should note is that a will passes property not during the lifetime, but after someone has passed. There also is the option of passing property during your lifetime by way of a trust. But I don't think we need to discuss that. That is a separate process on its own and probably more suited to high net worth estates because of the cost and process involved. And the last question had to do with alternatives to creating a will. And I think I covered that in the discussion I had before on being able to transfer property, what we say inter vivos, during your lifetime, transferring and giving ownership to your beneficiary while you're alive. Of course, you want to make sure that you've already preserved and have on hand sufficient cash, some other assets that can take you through the rest of your lifetime. The other thing that you should consider is that if you're transferring property, you can transfer property to a child as a joint tenant. So you're not transferring the entire interest or estate in the land to your child. You're still preserving ownership. So transferring partial interest to them as joint tenants, what it means is that you still retain some control over that asset, but when you pass and presumably the natural course of nature takes place and you predecease your child, then your child has a right of survivorship and they remain untitled, and there's no need for probate. So the question in relation to, or my thought on having a will. So you can prepare a simple will. You must make sure that the will is witnessed. It must be witnessed by two persons. They don't necessarily need to know the contents of the will. That's personal. They just need to be together in the same room and witness your signature. We also need to understand, it must be clear, that marriage invalidates any previous will. So if you've remarried, you want to make sure that you have, you prepare a new will. Also, what you want to make sure is that the beneficiary or a named beneficiary does not witness the will and must not be either your spouse or spouse of a beneficiary. And so those are some very important steps to take into account. Also, it's important that you appoint an executor. And so an executor is a person who will carry out your wishes. They will they'll take steps to engage an attorney or solicitor who will then do the necessary applications for the probate. And that's essentially some of the basic steps that you would want to take into account. And so, Paul, I think I've said a mouthful. You can jump in here. I know I was going fairly quickly.
Well, first of all, I think that you've answered your questions in quite great detail, and probably what I should do as a real estate agent is to try to encourage people to make a will and how simple it is, and that there are the professionals on board to assist with probably the stamping and getting the document registered. And the whole probate thing, I think people don't always understand that. I think they think once you've made a will, that's all you have to do. But they don't always understand that you have to now make it official. But it's good to know that you can just make a will simply, just write down what you need and what I want my jewelry to go to my niece Suzette, and I need my clothes to go to a charity, and my house is to go to, let's say, Salvation Army, and that actually even consists, that is a will. It doesn't have to be complicated, but I suppose when you have probably multiple properties, you've got lots of children, then you really do need to get legal advice on how to make that division a lot easier. One of the things I'd want to know, though, what happens if you have made a will and one of those people in the will contested? So you said, I'm only going to give a penny or $1 to my youngest son because he never treated me well when I was young. So how does that affect how how long it will take to probate a will? Is it what's the best thing to do?
Generally, once the will is determined to be valid, and that includes that the testator or testatrix, male or female, was of sound mind, then the court will honor their wishes. And so
right.
A recalcitrant or dissatisfied or disgruntled family member, it will be very difficult for them to rebut that presumption.
Right.
Where we see,
Sorry, go ahead.
Now, where we see that arising is perhaps where you may have had a family home. So you have a husband and wife, children growing up in a family home, and the father, let's say, remarrying years after and having a second family, and the property is left to a child of that second family. Then you may find an instance where a child of the first marriage may say, this is unfair, this was our family home, we all grew up, we all had, quite a bit invested in this family home, and this is patently unfair. Then there could be some challenge.
And how long does it take to complete the probate?
Well,
there's different opinions.
Gladly you're asking me this question, 2020. Maybe if you asked in 2018, 2019 and before, I would say 2-3 years.
Okay.
The probate division at the Supreme Court in Jamaica, they have taken a number of steps to improve the process. And so I would say reasonably within a year, once the application has been submitted with all the requisite documents.
Yeah.
It can be less, perhaps 6 months.
Well, that's encouraging because, we're hearing stories where probate has been going on for 3 years and more. And obviously that's in the past. So is there any way that we could say that somebody has a probate case going for, let's say 5 years, let's make it really dramatic. Is there any way now that you can pull that case forward and speed it up?
Well, a lot depends on why it has been lagging. So you'd want to look at some of those issues and make sure that they're being addressed. Also, you want to not have a will, because then the process of letters of administration, which is the counter to the probate application, can take much longer. The court has to appoint a trustee on behalf of the estate. One of the things I would say as well, coming on from your earlier point, is that when your clients engage in a purchase and they're purchasing a house, that conversation be had with them about estate planning and leaving a will. Also, what we try to do when there is more than one purchaser is, well, not what we try, we actually have this discussion, is discuss the options of either owning as tenants in common or owning as joint tenants. Generally, the preference is joint tenancy. In the case of joint tenancy, as I said earlier, it's the surviving party that holds the ownership interest, and the deceased party is unable to will that share. The challenge with the tenants in common is that each person owns their own share. One person can will their respective share, but what can then happen is the surviving person in occupation can end up having joint ownership of the property with someone who they're totally unfamiliar with. And then that lends itself to conflict. And then I think ultimately the preferred route is selling the property and each party getting their respective share in the sales proceeds.
So just to confirm, are you saying that at the time of the purchase that you're doing the sales agreement, etc., is it at that time you have a discussion about estate planning?
Yes, I think that's a good juncture. The home ownership process is a fairly significant life change. Persons are acquiring substantial assets. And so it would be an appropriate time to bring that to bear. I think prior to home ownership, persons may feel that they're not substantially, have the required net worth to consider leaving whatever they own to third parties, sibling or child.
And another question is, how would you advise somebody then who, let's say, a parent, single parent, because it can be male or female, and they have a child and they're making a purchase? What is the best way to deal with your child inheriting your property?
Well, one of the things you can do is include that child as a joint owner, joint tenant. And so that precludes the need for probate. Effectively, what happens, as I said before, presumably the parent dies, then that child would remain untitled. The only thing we would need to do is an application to remove the death of a joint proprietor, which is a far simpler application than having to do probate. You also need to bear in mind, though, that if there's to be a mortgage, there would have to be considerations as well, because the child as a joint owner, you would need that child's joint approval for mortgaging the property. And so it's something that you have to know your relationship with your child. It's not typical, but not unusual that, relationships can sour. And there are difficulties between the child and parent in relation to an asset that the parent really has ultimate control, but for convenience made this consideration.
Yes. And what about if the child is a minor?
Well, the child is a minor. You can include them in trust on the title, so that when they become of majority age, that ownership interest crystallizes or manifests.
I think that's good.
I think we've exhausted it, Paulette.
I think so too.
Well, I think we've touched on some very interesting points today. Thanks for your questions. I'm sure our listeners and viewers will benefit.
Yeah.
And
I think what we have done actually is given people nice chunks of information to actually think about without making it complicated. This is really an important part of real estate purchase. And I think a lot of people just buy a house and then pay their mortgage and just carry on, not thinking about the day that, you may no longer be around and what happens to your assets. And I think as well, a lot of people think, I need to have lots of things before I make a will, but you don't. You should be making a will, I believe, at whatever stage you start acquiring. And as you acquire more and more, you just simply update your will. And then you will need to update your will as the laws change as well, because you don't want your property to go somewhere else. If you wanted to go to A and now it's going to go to B because a law has changed and you just haven't followed up with that. And also, you don't want it to be overwhelming, because it will become overwhelming when you've got lots of things all over the place, because you sometimes find a married couple would buy things together, and then somewhere along the line they start buying things on their own, then their relationship changes, and then they have to sort through the whole pile of things. So it really is important to start at an early stage. That's what I think.
I think, too, Paul, at the bottom line is you don't want your life's work to go to the state. And for our UK viewers, they need to get estate advice. In the UK, there's a particular threshold of value over which at least 40% of your estate is taxed. And so you want to look at putting maybe a simple trust in place to own some of your real estate assets. So, I think we've gone the spectrum, and I think we've covered quite a lot today.
Yes. And I think the same advice goes to people, the diaspora in different parts of the world, the Canada, the US, and US is probably even a little bit more challenging because every state, their laws are slightly different. So that's something else that they should also consider. And the diaspora also in other parts of Europe. So you really do need to think about all of those things.
Well, Paulette, I think we covered quite a bit today.
Yeah.
Thanks to our viewers. We'll see you next week, Home and Away Jamaica TV. Thanks for showing up. Please send your questions.
Take care and stay safe.
Thank you. See you soon. Bye.
Bye.
Oh na 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 na. Bamba.